Hi, welcome. It's Sarah Shooter and Sarah Fox. Today we're going to be talking about which is better, mediation or adjudication. I'm Sarah Fox from 500 Words, and I'm a construction lawyer and contract strategist. And I'd like to introduce my co-host.
Hi, good morning, Sarah. Morning, everyone. I'm Sarah Shooter. I'm also a construction and engineering lawyer. I run a little business down here in London in the UK. We're going to be talking about mediation and adjudication. And shall I start with the mediation? I think
Yes.
that came tops first. Okay, so some quick facts on mediation. Mediation is a consensual process here in the UK. It is a means by which two or more parties agree that they need the help of a third party, an independent third party, to help them to resolve their dispute. Now, mediation in the UK can be used for any kind of dispute. There are mediators who specialise in different sorts of dispute, and that brings to the process a particular expertise, but you can use mediation for any type of dispute between parties. So the third party is appointed jointly and is paid equally by those parties, and that third party mediator acts as a facilitator. Okay. So he or she doesn't decide the dispute and doesn't impose any kind of decision, but works with the parties to try to help them to come to a decision together themselves. Even though they're in a dispute, there are very skilled mediators out there who can help the parties to do that, and very successfully. Mediators can be asked to give a non-binding opinion, which then the parties can take away and think about whether that might assist them to go down a particular path or not, either in litigation or in a different type of ADR forum. That can be extremely useful as well. But in essence, we have the two or more parties coming together with an independent third party, and together they try to solve the problem. Now, the great thing about mediation is it can be set up pretty quickly, and it can get rapid results with the right kind of mediator. So
I was reading some statistics, Sarah, that CDL says that 80% of mediations are successful, not necessarily always on the day, but within a certain period, 80% of the things that have gone to mediation will have settled in one way, shape or form without the need to go all the way to trial.
I think that's a great statistic, and I'm surprised it's that low, actually. I would think it would be at least 80+%, because mediation is so flexible. The great thing is that you can go away one day and then decide to come back. Mediation is not time limited in any way. The parties are not held to any kind of limitation period or anything like that. Of course, there might be other limitation periods under the law which might push them in a particular direction or another, but mediation of itself is not limited in any way. It doesn't need lawyers. Okay, it can be used by the parties by themselves. Professional advisors can provide a very useful strategic steer through that process, and can obviously provide legal advice on particular points. But mediation is not about getting the right legal answer. It's about getting an answer which the parties can live with as between themselves, which preserves their business or other relationship, and which provides the ability to do other things outside of legal rights and wrongs.
Good, excellent.
Tell me about adjudication, Sarah.
So adjudication is a quick process. So again, it's easy to set up. There are specialist adjudicators who have experience in particular types of dispute. They're listed under various different professional bodies. So there's, like mediators, there are lists of adjudicators that are mediators. It should take anywhere between 28 and 56 days to get a decision, but this is a decision. Unlike mediation, it is based on the law. It is based on someone imposing their opinion based on the evidence given to them. Now, because it's a very quick process, you can't have very complicated disputes resolved properly through adjudication. So they tend to be sort of more single issue disputes, whereas mediation can resolve lots of things to do with behaviour, personality, law, commerciality, all sorts of different things can be resolved in mediation. In adjudication, it tends to be legal issues. So are they due more money? Are they due an extension of time? Were they entitled to suspend? Is there a contract? What are the terms of the contract? That sort of thing. So it's specifically designed. Go on.
I was going to say valuation disputes are a common subject matter for adjudications because they tend to be relatively fixed in terms of their parameters, and there's simply a question as to whether the correct valuation has been made or not, and if it isn't, then what is the correct valuation?
Yeah, and then it's interesting that adjudication is better with a narrow focus, and mediation can be better with a wide focus. Then, because then you can deal with everything that's been bothering people and clear the air to go forwards. Adjudication is meant to be done as the process continues, as the project continues, but it doesn't necessarily clear the air because you have to keep it neat and tidy. So that doesn't necessarily give everyone an opportunity to have their say and get it off their chest and that sort of thing. So adjudication was designed for the construction industry. It's for construction contracts, which has got a very specific definition taken from a tax act, so slightly more complicated. But essentially, you can choose to adjudicate even if you're not statutorily required to adjudicate. And it's a bit like mediation. You can decide after a dispute has arisen to go to either of these two dispute resolution methods, or you can write them into your contract. Either of them works. And in fact, some people would say that mediation, if you put it in your contract but don't really want to do it, then probably it's not right for you. So that putting it in your contract doesn't necessarily help you to decide whether it's good at this precise moment in time for this dispute.
I agree with that. Whether or not you write mediation in, to my mind, makes no difference at all. It's all about the attitude of the parties and all about the kind of things which are, as you say, bothering them, that they want to get resolved. Mediation, of course, can't be imposed. It can't be imposed contractually, and it can't be imposed by the law. However, the court guidance nowadays is such that, and the case law that follows that court guidance is such that the encouragement, I'd say it's almost mandated, but of course it can't be because it's consensual in its philosophy. That court guidance will be applied to the letter. So anybody who doesn't reasonably and sensibly opt not to go to mediation, in other words, there's no good reason not to try it, could face some pretty harsh, some pretty severe penalties from the court if and when that dispute does go to court and you know, a judge finds out, which he will do because he will inquire as to the parties' behaviour and the kind of steps that have been taken to resolve the process outside of the court process, to resolve the dispute outside of the court process. You know, so if parties have just been going through the motions of mediation, for example, or there has actually been a blatant refusal to go with no very good reason why not, then you know, one could find, it's a cautionary tale, one could find oneself on the end of some pretty severe cost penalties, including not recovering your own costs, and then you have a pretty severe discussion with your lawyers as well. So the downside of mediation is that you can't impose it, but it's also its upside. But a word of caution to make sure that if your alternative formal process is litigation, then you must think very carefully about whether to go to mediation or not. And the great thing is it can be set up really quickly, and you can just get on with it and air everything out in a without prejudice, open forum, and really have a kind of a heart-to-heart in a way that can really help.
Okay, so if it's in your contract, you can't really avoid it. Mm-hmm. And in fact, if you go to court, the court will stop your court proceedings and tell you to go off and do the mediation. Because if you refuse to mediate without good reason, then the court can say, well, we don't think you should have taken this to court, and we're going to penalise you by not allowing you to recover your costs. Now, what happens if you've started an adjudication or started a mediation and actually somebody then decides to adjudicate? Can they do the same thing at the same time?
Well, of course, adjudication is a statutory right in the construction engineering industry. So at any point, if you have the type of dispute which falls within the remits of the statutory regulations, the scheme for construction contracts, or your contractually imposed version of it, one is in adjudication, and that is imposed on you, and you have no way of getting out of it. The mediation would have to be paused, and the adjudication would have to continue.
Okay. You don't really want to be doing all these things though at the same time, do you?
You don't, no, absolutely not.
Adjudication, you have a statutory right to do at any time. So even if somebody started arbitration, mediation, litigation, you can still adjudicate the dispute. Now that can resolve things much quicker than most of those other procedures. And mediation still has a bit of upfront work to be done to make the day of the mediation or the couple of days of mediation the most effective. So that's one of the reasons why they'd like to pause the mediation process, because actually sometimes the adjudication can resolve everything that was going to be dealt with in the mediation itself.
It can do, and it can pull out those relatively limited issues from the mediation. So even if there are things remaining that can't be resolved by adjudication or haven't been referred, is the better way of describing it, or haven't been referred to the adjudicator, so the adjudicator doesn't have jurisdiction to deal with them, then those can be left over and pulled into the mediation later. So it's good in a way that we have these two alternatives that can play off each other.
And they're both reasonably quick, but which is the quickest, you reckon?
Well, adjudication is probably the quickest because there is an imposed timetable. The adjudicator will take charge of it. By default, the process is 28 days. You can add another 14. The parties can add further days to that. But of itself, it's 28 days from start to finish. And that's the start of the process to the decision being delivered.
So how long would a mediation take?
Well, it's probably, the mediation itself is usually only 1 or 2 days, or at least there's 1 day and then there's provision for the parties to sort of reconvene after a couple of days, something like that. It's the time taken to set up the mediation. Getting the mediator on board can be done within a few days or 1 business week. It depends how strategic the parties or their lawyers are about it in terms of how long it takes to actually get to the mediation table and in the room with the mediator. And that's where mediation struggles a bit, because it is at the mercy of the parties, and its flexibility and its consensuality is vulnerable.
Okay.
It's vulnerable to being used strategically, sadly.
If you had a client who had a reasonably small dispute on fairly limited grounds, which is the easiest to run if he doesn't want to get lawyers involved?
The easiest to run would be adjudication, because adjudication is set up for users. And this user who doesn't want to use lawyers or doesn't see the need to invest in that kind of money in order to get a relatively small, relatively limited dispute resolved should go straight to adjudication. No doubt. No doubt in my mind about that. Would you agree?
Yeah, I would agree. Now, the thing about adjudication is the adjudicator puts his decision together. The thing about mediation is sometimes the mediator isn't that good at putting the decision into a legal form, because if you actually get to the end of a mediation, you've come to a compromise, that becomes a contract in itself, doesn't it?
It comes a contract when it's reduced to writing, and that's the important thing about mediation, is to make sure that the terms of the mediation are satisfactory to both parties. So there is no decision unless the parties want to have a decision, and that decision needs to be what we describe as reduced to writing. So it needs to be written down in terms which are clearly understood and agreed by both parties, and there needs to be somebody with authority attending the mediation, either in person or who has authority to deal with it afterwards. And that's also important, because the mediation can the benefits of the mediation can very quickly fall away if those kind of niceties in a way are forgotten about. Yeah. So we can go all the way through the process and get to the end, and then you find out there's nobody there who can sign. That can be really frustrating to the parties, especially at the end of a long time. So we need to make sure that you get those things set up for the mediation. And whereas it doesn't matter, because you're giving somebody else the authority to make that decision for you.
And it's really important, if you go to mediation on a construction dispute, some of the things you could agree would be to do with rectifying defects, carrying out further works, providing further services. Now then, the agreement that you end up at the end of the mediation can itself be a construction contract to which you are entitled to adjudicate afterwards.
And you can end up
and if you don't have people in the room who understand the provisions you need for a construction contract, you end up with a mediation agreement that then gets imposed more terms on it by the Construction Acts.
That's right. And then that becomes a contractually binding thing, and in essence, the contract itself then gets expanded in some way, which wasn't necessarily foreseen at the beginning. So yeah, absolutely, be really careful about that.
So which do you think is better at maintaining commercial relationships?
Oh, mediation, without a doubt. That's its purpose, really. We're there to get answers, yes, but we're there to get answers which are commercially attractive and sensible for the parties. There's also no doubt that adjudication can work and can preserve commercial relationships, but because of its adversarial nature, because of the fact that you're giving power to another person, that has a very profound effect, in my experience, on the kind of experience people have in adjudication. Taking control and maintaining control, albeit with the help of a third party, can in itself be a very powerful thing and can really help the parties to cut through the emotion and to cut through the difficulties that they've been having, and to admit to themselves and to each other that perhaps things haven't gone so right, but actually they're both here for a purpose, to make it better, and that's the aim of the game.
And would you wait to the end of your project to do either of those? Or I know both of them you can do at any time, but the statistics show that the vast majority of adjudications and mediations still take place after the practical completion and even after the defects period. But would you actually recommend people took the bull by the horn slightly and actually did them as they went along, to clear the air, to keep things on a tight footing?
I would definitely encourage parties to do that. Our industry is terrible at sort of putting our heads in the sand and leaving things until the last minute and trying to wrap things up right at the end of the contract. A lot of money is lost at that stage, a lot of profit, a lot of goodwill. I think these processes can be really, really useful in their own ways during the project, during the delivery phase. And I think people need to take a brave step and actively think about using one or both of those processes and carrying on the project at the same time. It's entirely possible and can be extremely useful in keeping the thing going, not storing up all this stuff until the end. Good.
Anything else you want to say about mediation? Although you do seem to be its biggest fan at the moment, Sarah.
I am a big fan of mediation. I think it has some really, really fantastic benefits, which are much, much wider than just getting a dispute solved for the benefit of the parties. I'm a big fan of it.
And I think mediation, though, has been around for a lot longer. So actually mediation is almost what King Solomon did when he looked at the two babies.
Absolutely.
But
been around since dinosaurs.
Adjudication is still not well enough known within the construction industry, and it's amazing the number of times that I have clients who've not been given a payment notice or pay less notice, whatever, and have no idea that they can get a very quick answer that will actually force the other side to pay them.
Yeah, that's right. So how often is that happening with you and your projects at the moment, Sarah?
Well, often the reason people come to me is because they haven't been paid. And then when you look at the background, you see the contract paperwork is pretty poor. So they haven't actually issued the notices that they're meant to have issued. So you could say to them, well, the thing is, you could actually take this really quickly to adjudication. And the problem is, because it doesn't maintain commercial relationships, it sets one party against the other. If they're in a small geographical area, that's not in their interest. So adjudication doesn't necessarily, it can solve disputes quickly, but it can also break relationships. And that, for a lot of people, is worth a lot more than the amount of money they might be chasing.
That's right. And as you rightly say, in a small geographical area as well, where perhaps things are fragile economically or fragile within the industry, or perhaps it's just a small pool of suppliers or contractors to choose from. I think those very small businesses are running a very difficult, walking a very difficult path in many ways. And as you say, they're put off by the fact that it is an adversarial process, or it seemed to be an adversarial process. I don't think it necessarily has to be. There's maybe a maturity and an education that needs to be appreciated.
Okay. So do you want to sum up mediation in 30 seconds?
That's a long time. Okay, mediation. Mediation is a fantastic, consensual, flexible process by which parties can jointly agree to appoint a third party, an independent expert who's going to help them to resolve their dispute. They're going to air all sorts of things at the mediation table in an open and transparent fashion, and they're going to try at the end of it to get to a point where they can both live properly and reasonably with the end result.
Fab.
Can you do the same for adjudication, Sarah?
Of course. So adjudication is a statutory process for construction contracts. It can be used at any time. It is a very fast, furious and quick procedure. You have somewhere between 28 and 56 days to get a decision imposed upon you that can help you to progress the rest of the project, to get on with your life, to get some money. Often it's money that is in dispute, and it should be quick, simple. You don't need lawyers. It's a reasonably simple process to go through. The most important thing, though, is that people involved in construction projects are aware that that is something they should be doing. They should get used to the procedure, because once they've done it once, then they'll find out how useful it is. But it's that fear of getting involved, the fear that lawyers might cost them lots of money and all that kind of stuff. So if you're in the construction industry, this is a process you should be becoming familiar with, should be using, and use it to good, because it can get you money much more quickly than just hanging around and sitting back on your chair and hoping for some money to come in.
Perfect. Thank you.